I interrupted you before out of a point of order because we had 3 conversations going. I'm going to ask you, please, it's a matter of civility, to respect the chair. All right? If I need to control the meeting, I need to only have one person speaking at a time.
Okay.
Go ahead.
Okay, I've got a letter. I would like this to be read into the minutes of tonight's meeting as opposed to into the record. A couple of things have already been touched on, but I want to read it as written. Dear Zoning Commission members, I have several questions and comments regarding the proposed zoning regulation changes as follows. 1, who wrote the proposed changes, when they were written, and when were they written, and at the direction of whom? 2, the Planning Commission has found the draft revisions not to be in compliance with the Woodbury Plan of Conservation and Development, so why are you proceeding? 3, First Selectman Jerry Stomsky's comments at the November 9th, 2011 Planning Commission meeting included that you have not approved the final draft yet, and it would come before the Planning Commission prior to a public hearing for their comments. Since you have yet to approve a final draft, isn't tonight's hearing as inappropriate as putting the cart before the horse? 4, you propose further restrictions on political signage, yet the issue of your ability to regulate them beyond regulation of other local signage is being hotly contested. So why do you bring this up now? Our Connecticut Constitution states, quote, no law shall ever be passed to curtail or restrain the liberty of speech or of the press, unquote. That sentence is quite clear, and yet you seek to undermine it. At a meeting 14 or so months ago, the fact that your regulations and actions were also against the U.S. Constitution and its First Amendment, and that you are attempting to deprive me of my constitutional rights was brought up. These rights are guaranteed for every U.S. citizen, yet Chairman Overton stated that you were not going to discuss, quote, federal regulations, end quote, at the time. It's not a regulation, Martin. It's the U.S. Constitution. It guarantees our rights against people like you who would take them away. Attorney Deborah Stevenson appeared with Art McNally at your meeting to verify this and reference case examples. Mr. Overton's own recent headquarters use of signage exceeding current regulations show him to be hypocritical on this issue. The fact that I was again singled out for a violations letter underscores your discriminatory enforcement attempts, not to mention your chairman's unwillingness to comply with the regulations when pursuing higher office. 5, Chairman Overton has stated that the current regulations were voted into effect by both the Zoning Commission and by, quote, the people, end quote. My 20th September 2011 FOI request to Zoning Commission members and Donna Szynski asking for the meeting minutes and or hearing minutes where this occurred was answered with, quote, in researching your request for meeting minutes in regards to the current political sign regulation when they were voted into effect, I have found that it is not specifically stated when that regulation was changed. The description of, quote, political signs with square footage criteria, end quote, appears to have come into effect in revised zoning regulations of January 1st, 2006. Should you have a specific date of meeting minutes that you require, they are readily available in the town clerk's office. That's the end of what her letter said to me. Do you truly have no record of the process that Martin has referred to, or is it possible that it was not voted on as has been said? Aside from number 6, aside from the Planning Commission, does any other board, commission, agency, etc. have to review your final draft once you create one? Respectfully submitted.
Thank you.
I agree with Mr. McNally. I don't think that you have the right to regulate political signs. Back last October when this started, when you had promised us that it would be a 3-month process, Mr. DeLuca had told you about the Supreme Court decisions and how it was always decided that you can't curtail signage, political signage, to any smaller than any legally allowed sign elsewhere in town, and yet your restrictions here are even more confining. What you have in the draft regulations here. It just doesn't make any sense, and I will go back to and reiterate that just to proceed without knowing this letter we've sought since June is ridiculous, and I think that you really fouled up by scheduling this hearing as such. It's not that everybody should show up now and then you're going to release it next meeting after we've spoken our piece. That's not really the fair way to do it, and everything you're doing is incredibly unfair.
Thank you. I'd like to address a couple of your comments.
Okay, I will submit that.
And the same as Ron Jackson's comment earlier, we didn't want to see some of the regulation changes. I believe we've been at this for almost ever since we approved the previous revisions, which was in May of 2010, so whatever that is, 18 months we've been at this, and a lot of the changes that we made in draft form are generated out of statutory changes. So if the statute changes, we are required to update the regulations, so that's one. The second area is that during this period of time, the state passed a law requiring control and regulation of certain land uses that may impact public water supply. So we responded to that through creation of an aquifer protection agency, and then our attorneys advised us to amend the actual zoning regulation to cover what the Aquifer Protection Agency wanted to accomplish in the way of protecting water supply. And then finally, and I think your point is as to the sign regulations, those changes were created either by staff or by staff and attorneys, by staff and attorneys of the commission over a long period of time, Tom. So it isn't like at one meeting we created a set of regulations in draft. That didn't occur that way. This is kind of an agglomeration of a whole lot of requirements. As far as holding the public hearing, I mean, you made a point about final draft, which, if you like, is a bit of an oxymoron because it's final, it's not draft. At some point in time, you have to stop the process in order to get in front of the public and get comment. Okay? I have absolutely no doubt that as a result of this hearing, the language we have in draft form will be changed. This commission will respond to the people, to things that you've said, and to what other commissioners have said. I mean, I'm hearing from two of the alternates tonight that, if I paraphrase what they're saying, they need more time to be able to look at these and to discuss them. Okay? In the context of holding a public hearing, that is the right format. It doesn't end the process, it's the core, it's the middle of the process. The end of the process is when everybody around this table agrees we're done. And it doesn't really end until we agree we're done. So there is no clock ticking by which we have to arrive at a decision by a certain time.
Okay, when you have stated that as the people have voted, who were the people?
I'm sorry?
You have said as on the previous regulation, earlier in dialogue earlier last year.
Well, I don't think it's relevant to tonight, but Tom, I want to get to other people. But Commissioners Overton, Clark, Cosgrave, Freen, Teets, alternate Zolper, Conter, Judson, and former member Barbara Parkinson all voted on this, or worked on and voted on this.
The current ones.
Right.
But we never went over the final draft and talked about it.
Correct.
As a group.
Correct.
It was
This is
thrown
the
up
format.
at a couple meetings ago and sent off, and we should have talked about it, discussed these changes, and discussed what you were doing with it, because this is not what the state wanted to have.
I have a question, Mr. Chairman. You just made in a statement that the attorney advised you to write the aquifer protection rules as they are. That you said
that's not exactly. We referred to the attorneys for an interpretation of what was actually behind the aquifer protection regulations, so we could, the aquifer protection statutes, so that we could generate an aquifer protection district regulation change that would not be in conflict with that. We needed a legal opinion on that.
I get that, but when you're, I'm just confused because you said something that I'm confused on. We're talking tonight with the public and the commissioners about banning 28 businesses in the entire town of Woodbury.
I'd like to address that in due course, because your point is a very, very important and very valid point. That's not the intention of the regulation. But the way to get to that is to complete the public testimony part, and in discussing the testimony as a commission, you're going to raise the issue that this is what it appears to do, and I'm going to agree with you, and then we're going to draft language that changes it. That is the process here. Right now, we're asking the public for their input into this.
I know I'm new, and I thank you for obliging me. It wouldn't, to me, it would seem relevant that the public would want to know why that step was made, and they would maybe want to comment on that. That's just my opinion. As I said, it's my first meeting, but it seems appropriate.
Understood.
Yeah.
But there are going to be other changes which this commission may wish to make to the language, just like you're suggesting that this language appears to ban businesses when it actually doesn't. That's not the intent. There are going to be a number of issues like that. I'm going to guess